Yes, we are live. So, good afternoon, everyone. Today it's our second session on GST certificate program. 10 days. It's a 10 days program, and I request everyone to kindly keep your Zoom audio mute throughout the session so that we can have a smooth session. And now I request Nitesh Moji, president of our association, who is working very hard to organize such kind of seminar throughout the years. And over to you, sir.
Thank you, Manurisi ji. Welcome you all to this second day of the 10 days GST course. Friends, we thought that after the 6 years of GST, we should have one kind of program where members can have in-depth knowledge about the GST litigations part. So that is why we had organized this kind of course. Today we have eminent speaker, advocate CA Gaurav Gupta ji. So welcome you, sir, and the chairman
Thank you,
Aishwarya ji
sir.
from the Raulkela. Welcome you, sir, and welcome all the delegates. I wish this program a great success. Thank you, everyone.
Thank you, sir. I'll just read a brief profile of CA Aishwarya Agarwal ji. Aishwarya Agarwal ji, a qualified chartered accountant, company secretary, and law graduate. And he is a partner in Aishwarya and Company and knowledge partner in RPA Professional LLP. He is having more than 10 years of experience in the field of indirect taxation, that is GST, service tax, central excise, and VAT. He has worked with various type of industries like iron and steel, FMCG, cement, construction, healthcare, and etc. Aishwarya Rai has a wide range of experience in providing consultancy, corporate training, drafting show cause notice, replies, and appeal, and also appearing before tax authority and tribunal. He has an experience of working with leading indirect tax consultant of India. Aishwarya Agarwal is past chairman of Raulkela branch of EIC, ICA in year 2019 and 20. He is selected faculty of Indirect Tax Committee, ICAI, for GST and appointed as knowledge partner of Tele Solution for GST. He has also conducted workshop on GST for Central Excise and Service Tax Department. Aishwarya has his own YouTube channel in the name of C. Aishwarya Agarwal, where he shares valuable insight to keep you informed and empowered in the ever-evolving landscape of GST law. His channel is a hub of insightful content on the latest update and case law in GST. He is regular speaker in various professional studies circles, seminar and conference organized by ICI and trade chambers. He has also been appointed as legal advisor in Raulkela Chamber of Commerce and Industry and is a regular contributor to various online publications like Tax Guru and TMI. We welcome C. Aishwarya Agarwal ji for this center. Now I hand over CA Suman Chaudhary ji to read a brief profile of Advocate Gaurav Gupta ji.
Thank you, Manirisi. Today we have our speaker, Mr. Advocate Gaurav Gupta. He is a graduate from Sriram College of Commerce, Delhi University, and a law graduate from Delhi University. He is a fellow member of our institute. He has been complemented his master's in LLM in 2021 from OP Jindal Global University. He has completed his ISA post-qualification course from ICAI. He has also obtained his doctorate in taxation from France, University of France. He is practicing as advocate in Delhi High Court and tax tribunals. He is practicing as advocate in High Court, especially Delhi High Court, tribunals, and other courts. He has more than 18 years of experience in indirect taxation, during which he was extensively involved in consulting and litigation of SSC, including multinationals and domestic company across a range of sectors such as infrastructure, power, education, medical, communication, telecommunication, broadcasting, IT, FMGC, financial service. He specialized in handling enforcement, audit, litigations matters in indirect taxes in India. He has also worked as a head taxation in listed companies and retired with one consulting firm in indirect tax space and had worked on assignment involving provisions of opinion and consulting on Fortune 500 companies. He also is the author of books, too many titles on GST, including Comprehensive Analysis of GST on Services, Goods and Service Tax Law and Practice, Handbook on GST Law and Practices, GST Hand Guide and Practitioners, GST Manual, GST Referential and Manual. He is the co-author. Audit and Annual Return in GST. He is also the co-author there. He has authored books in service tax titled Service Tax Law and Practice and Service Tax Ready Reckoner. He was contributory to various publications of Indirect Tax Committee of the Institute, and he was adapted a complement to all other circulars, notifications, and everything. He has also been specially invited to the Indirect Tax Committee of ICI for the financial year 12, 14, and 17, 18, 19, 22, and 23. He was co-chairman of Indirect Tax Committee, PhD Chambers of Commerce for the financial year 1920. He is the vice president of Sales Tax Bar Association, Delhi for the financial year 23-24, and was elected as the executive committee member for the financial year 21-22, and is joint secretary for the financial year 2014. He was a special invitee to National Executive Committee of all India Federation of Tax Practitioners and members of the Indirect Tax Representation Committee of all India Federation of Tax Practitioners for the term 2022. He was a co-opted member of the Strategy, Perspective Planning and Monitoring Committee of ICI for the year 21-22. He is a founder member and executive member of the Society for Tax Analysis and Research. He has been ex-senior advisor to World Association of Small and Medium Enterprises. He was also a member of the Managing Committee of India Tax Practitioners Association, Chhattisgarh, Raipur, India, and the member of the Committee of Sales Tax Bar Association 2016, 18, 19. He has also been convener of the Delhi Study Group on GST ICAI 2016 and a member in the Tax Committee Association. He has addressed more than 600 seminars on indirect tax in the various forums, seminars, conferences, etc., organized by professional bodies and associations, including PhD Chamber of Commerce, Institute of Chartered Accountant of India, Institute of Company Secretary, and Sales Tax Bar Association, National Chamber of Commerce, and Southern Gujarat Commercial Tax Bar, etc. Is also a faculty of GST and Indirect Tax organized by CAI, GST Commissioner, etc. Thank you, sir. Thank you and welcome for this webinar. It's over to you, sir.
ऐश्वर्या जी आप म्यूटेड है.
Yes, sorry. Thank you so much, Sumanji. A very good evening to all the present, to other president of Views Exchange and other office bearers, our very learned speaker, Advocate Gaurav Gupta ji, and the participants present. This course was a much needed course, and I would like to thank Views Exchange for organizing this course on litigation, because जैसा Nitesh ji ने कहा कि it has been 6 years since GST has come, and you can imagine कि इस complicated law में अभी तक कितने सारे litigations हो चुके हैं, and it is already a time when the tribunal is also getting formed. So there is a lot of litigation, and it is the right time for us, the practitioners, to get geared up for this. And among all the topics lined up, I find today's topic, that is framing of issues for show cause notice, to be a very relevant topic and very important, because आज कोई भी litigation होता है, उस litigation का एक base होता है show cause notice. आपके जितने भी इन्वेस्टिगेशन में लेटर्स एंड करस्पॉन्डेंस होंगे डिपार्टमेंट के साथ, बट शो कॉज नोटिस इज द प्राइमरी डॉक्यूमेंट, द फर्स्ट डॉक्यूमेंट थ्रू विच द लिटिगेशन स्टार्ट्स, एंड इट इज वेरी इंपॉर्टेंट कि आप उसका रिप्लाई कैसे ड्राफ्ट कर रहे हैं, क्योंकि दैट रिप्लाई फॉर्म्स बेस्ड टू द लिटिगेशन विच इज गोइंग फॉरवर्ड. तो इसके लिए देयर इज नो बेटर स्पीकर देन एडवोकेट गौरव गुप्ता जी हु कैन गाइड अस ऑन दिस. इसमें सर को सेशन हैंडओवर करने से पहले आई वुड लाइक टू जस्ट इंट्रोड्यूस कि शो कॉज नोटिस होता क्या है. Show cause notice is like basically a document through which the taxpayer is informed कि आपने क्या violation of law किया है, आपका क्या action रहा जिसके through you have violated the law, the provisions of law, and इसके कारण आपके ऊपर क्या demand हो सकता है. That demand can be of any type, like it may be of overstatement of ITC कि आपने ITC excess avail किया, या there is short payment of your tax, या आपने कोई refund excess claim कर लिया है. तो इस तरह की कोई भी अगर आपके ऊपर डिमांड बनता है, तो आपको पहले एक शो कॉज नोटिस दे के आपको एक अपॉर्चुनिटी प्रोवाइड किया जाता है टू प्रोवाइड an explanation, a justification कि आपके ऊपर ये demand क्यों नहीं होना चाहिए. You have to show cause कि why the demand should not be made on you, and इसके साथ आपको एक opportunity for personal hearing बनता है. So it is very important to draft the reply in such a way कि आप अपने सारे issues जो आपको वहां पर allegations दिए गए हैं आप उसको address कर सकें. इसमें मैं बस अपने लर्नेड स्पीकर से रिक्वेस्ट करूंगा कि आई एम श्योर ही विल कवर दी सम वेरी इंपॉर्टेंट इश्यूज विच आई फील कि वो अपने डेलिब्रेशन में कवर करें, लाइक कि सर कि हम ये शो कॉज नोटिस को कैसे पढ़ें, बिकॉज शो कॉज नोटिस के कई पार्ट्स होते हैं. इट हैज एन इंट्रोडक्शन, फैक्ट्स ऑफ द केस, देन एलिगेशन, एंड उसके ऊपर फिर डिमांड. तो हमें ये शो कॉज नोटिस कैसे पढ़ना चाहिए. एंड प्लस जीएसटी लॉ के अंदर शो कॉज नोटिस के जैसे दो पार्ट है, डीआरसी 01 एंड उसका एक एनेक्शर. तो उसका क्या इंपॉर्टेंस है, एंड कई सिचुएशंस ऐसे होते हैं कि ऑफिसर इज इशूइंग ओनली डीआरसी 01, तो क्या अगर एनेक्शर नहीं है तो हाउ इट इज वैलिड और इन एन इनवैलिड शो कॉज नोटिस. प्लस शो कॉज नोटिस के सर क्या कोई प्री रिक्विजिट डॉक्यूमेंट्स होने चाहिए क्या, लाइक इन जीएसटी लॉ एक असेसमेंट के बाद आपका इन्वेस्टिगेशन स्टार्ट होता है. तो लाइक असेसमेंट के कई लेटर्स है, लाइक ASMT 10 या DRC 01A. तो क्या ये प्री रिक्विजिट है कि इस टाइप के आपके पास कोई असेसमेंट लेटर होना चाहिए, उसके बाद ही शो कॉज नोटिस फॉलो होगा थ्रू DRC 01, या स्ट्रेट वे कोई ऑफिसर आपके ऊपर DRC 01 इशू कर सकता है क्या. एंड देन सर वन मोर थिंग कि पर्सनल हियरिंग, देयर आर मेनी इंस्टेंसेस कि आज यहाँ पे शो कॉज नोटिस को एडजुडिकेट कर दिया जा रहा है विदाउट गिविंग अपॉर्चुनिटी फॉर पर्सनल हियरिंग. So how mandatory it is to give the opportunity for personal hearing, and how important a personal hearing is for us कि show cause notice के adjudication में हमारे लिए कितना important है. Along with it, is there any statutory time limit for giving the reply? Because show cause notice जब भी issue होता है तो ऑफिसर अपने साथ उसमें एक टाइम लिमिट देता है कि सबमिट रिप्लाई विद इन 15 days और 30 days, एंड देर इज अ पैनिक कि विद द टैक्स पेयर कि हमें रिप्लाई इतना दिन के अंदर देना है. सो वेदर देर इज एनी स्टेचुटरी टाइम लिमिट, क्या इसमें ऑफिसर हमें एक्सटेंशन दे सकता है या इसमें हमारे पास क्या पावर है. अलॉन्ग विद इट एक टॉपिक में साथ में है फ्रेमिंग ऑफ रिप्लाई टू द शो कॉज नोटिस एंड केस स्टडीज. तो इसमें सर केस स्टडीज में बिकॉज जीएसटी लॉ इज न्यू, देर आर नॉट मेनी जजमेंट्स ऑल्सो. तो इसमें सर अर्स्ट वाइल लॉज लाइक सर्विस टैक्स, एक्साइज एंड वैट के लॉज के टाइम के कई सारे जजमेंट्स हैं, कई अच्छे जजमेंट्स हैं. हाउ कैन वी यूज दोज केसेस in fighting the cases today in GST law? So with this, not taking much more time, sir, I request you to kindly take forward the session, and over to you, Sir Gaurav Gupta ji. Thank you so much.
Thank you, Aishwarya ji. Respected chairman of the session, CA Aishwarya ji, very respected CA Nitesh ji, my very learned colleagues Suman ji, Manu Rishi ji, the backbone of this session, Naveen ji, and all the other learned members who have joined this particular session, a very good evening to all of you. Our chairman session, Shri CA Aishwarya Agarwal ji, the kind of tone he has set for SCM, I think जो duty cast करी गई है, this is too much. It will not be humanly possible to cover everything what Aishwarya ji has said, but I'll try ki I'm addressing most of the issue what my chairman has put or casted the duty on me. So I'll take my time, and Aishwarya ji,
सर इसीलिए हमने चेयरमैन रखा है जो सब्जेक्ट का पूरा नॉलेज हो, नहीं तो क्या होता है ना कि हम लोग रहने से तो जो आप लोग बोले ठीक है.
नहीं सर आप स्पीकर है तो हम लोग भी चाहते हैं कि ज्यादा से ज्यादा चीज आपसे सीख सकें.
एकदम
अपॉर्चुनिटी कहाँ मिलता
है तो पूरा एकदम one of the best speaker.
It is always my pleasure, and Aishwarya ji, आपको जब भी लगे कोई questions वगैरह take up करने हैं, or we can take up at the end, or if you think anything which you want to elaborate, please, you are the one who will guide the session.
Sure,
so with your permission, Nitesh ji, your permission, I'll start the session.
Of course.
Friends, show cause notice. Recently, a spate of show cause notices has been issued by your state authorities, and very surprisingly, these came on the very last dates, 28, 29, 30th of September, which was the due date of issuing the show cause notice under section 73. One small thing, Naveen ji, if he is there, Naveenji, mistakenly, I think I have removed the spotlight from the Zoom. So if you can put the relevant people on spotlight, that will be great. So these show cause notices, which has been issued in the last 4 or 5 days, which was the due date of issuing the show cause notice under section 73 for the financial year 17-18, one can find that these particular show cause notices were issued in a mechanical manner, in a hurried manner, even though when we speak about GST, we all are saying now it is already 6 years. So 6 years, not only the assessee had, ये 6 साल डिपार्टमेंट के पास भी थे, और 6 साल के अंदर अगर किसी की कोई इंक्वायरी करनी थी, किसी का कोई स्क्रूटनी करनी थी, दे हैड एम्पल अपॉर्चुनिटी. सो जो ये लास्ट मोमेंट पर हरिडली ये जो शो कॉज नोटिसेस हुए, what is the relevance, how valid these last minute show cause notices are, and how should we approach them? I'll try to cover all of them, including the questions which my chairman has casted, including whether DRC 01A was important. For that matter, the timeline within which the hearings should happen. Is hearing mandatory? How much time we should take? All of these particular issues I'll try to cover within my session, sir. So to begin, just to give an overview, under the GST Act, you have multiple sections under which show cause notices are required to be issued. Starting with section 10, 21, 35, 50, 51, 52, 61, 62, 63, 64, 73, 74, 65, 66, 122, 123, 124, 125, 127, 129, 130, 76. All these 24 sections require the issuance of a show cause notice. Why specifically these particular sections? Because either these sections are taking away, please understand, these sections are taking away a benefit. For example, in section 10, the benefit of composition scheme. If the officer feels that you have infringed any of the conditions of the composition scheme and you're not no longer eligible for that, so he will issue you a show cause notice. Similarly, if he finds you a defaulter in TDS deposition or collection, again he will issue you a show cause notice before he will pass a adverse order against you. So any adverse activity, if the department is contemplating or wanting to undertake against any of the taxpayer, it is mandatory to issue a show cause notice. As very rightly said by the learned chairman, that show cause notice is a opportunity provided to the taxpayer why a particular action should not be taken against him, and which is obviously it is adverse, it is not to the benefit. If something is being to the benefit, I don't think anything is required. But if anything is being done against any person adversely, then you need to issue him a show cause notice. It is one of the trite principles of natural justice that no one should be punished unheard. किसी को भी सजा देने से पहले उसका पक्ष सुनना जरूरी है, और वही एक काम शो कॉज नोटिस करता है. क्या इसका ये मतलब है, अगर हम ये बात कह रहे हैं, if we are saying that it is an opportunity given to the other person, why this particular penalty or why this particular demand should not be raised against you? The show cause notice, the department has already made up the mind. Now, this is a very sensitive issue and it has to be seen in a very careful manner that even though show cause notice is driving towards a demand, if you find that the authority is biased, already it has decided that it will confirm the demand, that show cause notice is vitiated. वो show cause notice की जो महत्व है वो खत्म हो जाता. Because if someone is already predetermined that this particular demand is to be raised, and then he calls for a hearing, that hearing will never be a fair hearing. Fair hearing means you have an opinion, please hear to the other side, you might change your opinion. So if you are open with this particular thought that after hearing the other person, there is a possibility that you will change your mind, then in that particular case, that kind of fair hearing is contemplated under the provisions of the statute, and that has always been protected by the courts. I'll take you through some of the very important judgments in this particular context. So to begin with, first question which was raised was, if the time limit for issuing the order under Section 73 has been postponed or it has been extended till 31st of December 23, does the time limit for issuance of show cause notice under Section 73 was, even though not specifically extended by the notification, does it stand extended automatically till 30th of September 2023? Why this question came up? Show cause notice, order for 73 can be issued within 3 years from the due date of filing of annual return. The due date for filing of annual return for 17-18, as all of you know, was February 5 or February 7, 2023. Now that time has gone. We are sitting today in November, but when the show cause notices were issued, it was in September. The government has from time to time issued 3 notifications extending this particular time frame from 3 years specifically for 17-18 till 31st of December 2023. Now, the notification does not mention anything about the extension of issuance of show cause notice. So does it mean that issuance of show cause notice was at the same date which has been specified in the statute, while the date of order only has been extended? Now, this very innovative kind of question, it came up before the Honorable Kerala High Court in the case of Papachan Kaitiyat versus Assistant Commissioner. The Honorable Kerala High Court ruled out the petition and it ruled in the favor of the revenue that when the time frame for the order of financial year 17-18 is extended, then time limit for issuance of show cause notice is already automatically extended, because it is not an independent date, but it is a date which is in reference to the date of order. So since it is binded, because what is the date of issuance of show cause notice? At least 3 months before the date of order, and the due date of order is 31st of December. So show cause notice की अपनी कोई independent date नहीं है. Under Section 73, it has to be issued at least 3 months prior to passing of an order. Under Section 74, it has to be issued at least 6 months before the due date, the ultimate due date of issuing the order under 74. So please appreciate, this is a very welcome step on part of the government that it has now plugged the due date of passing an order under the GST. In the erstwhile Act, Service Tax and Excise, आप सबको पता है, while there was a due date of issuing a show cause, there was no due date of passing an order, and therefore those particular matters are still, those particular orders are still pending. Those particular orders are still pending to be adjudicated before the first the adjudication authority for more than 7 years, 8 years, 10 years. In recent cases, Delhi High Court has quashed some of the proceedings because the order was passed after a very undue extended time, 10 years, and therefore those particular orders were held to be unsustainable, and the orders and their proceedings were entirely quashed. So this one welcome step GST has, that it has a time limit for passing an order so that the demand is quantified within a defined period. What is the harm or what is the damage to the taxpayer? The biggest damage to the taxpayer comes out in terms of interest. आज की डेट में जो interest है, that is around 18%. If 5 years have passed, your tax amount and your interest amount is almost same. And therefore, if the time frame goes beyond 5 years, the interest amount becomes more than the basic tax amount. So that can never be the intent, that you keep the proceedings open for any taxpayer. If you have to create a demand, create it within a reasonable time. जब ये GST के annual returns की date बढ़ाई जा रही थी, I might be speaking, I've spoken in Kolkata also, I was one person who was requesting, please don't get the date extended. If you want a relief, write to the authority, write to the CBIC to waive the late fees. Why it was so? Because if you are wanting the extension of due date, the due date for issuing the show cause is also getting extended. So that was a big damage for everyone, that because the due date of annual return was extended, automatically the due date of issuance of show cause notice under 73 and 74 also got extended. And therefore, these proceedings, which are now being taken up after 6 years, for the first very year of the GST, are held to be within limitation and valid proceedings. Having said so, is the show cause notice a valid show cause notice? Now, in order to understand, let me first answer the question कि शो कॉज नोटिस के बहुत सारे पार्ट्स होते हैं, हमें किस किस पार्ट पे क्या क्या ध्यान करना है. आपके पास एक शो कॉज नोटिस आता है, मैं समरी और सेक्शन 73 मतलब DRC 01 इनके बारे में 2 मिनट बाद में बात करूंगा, बट मैं जो आपका शो कॉज नोटिस है, नॉट दी समरी, उसके जो ब्रॉड पार्ट्स ऐश्वर्या जी ने भी बात करी, मैं उनको थोड़ा सा और स्ट्रीमलाइन करके डिवाइड करता हूँ. शो कॉज नोटिस का सबसे पहला पार्ट आपका ये बताएगा कि ये शो कॉज नोटिस की जो प्रोसीडिंग्स है वो कैसे शुरू हुई. सो वेदर अ स्क्रूटनी वाज टेकन और वेदर देयर वाज एन इंटेलिजेंस, an ordered objection, any reference from a third party, where the proceedings started. The second thing will be what is the preliminary action which was taken, whether there was a ASMT 10 which was issued, or whether there was a search which was undertaken, whether there was any visit under section 71 which was undertaken, whether any inquiry or documents called in, summons were issued. So the first action of the authority will be first recorded that this is how the proceedings were started. Then what is the further investigations we took? So there will be a series or spades of letter which came from the GST authorities, how they were replied or not replied by the taxpayer, whether those investigations were completed in to the satisfaction of the investigating officer or not. Then he will present the summary of investigation. Once he has presented the summary of investigation, he will point out that my summary and my observation, please note the word, I'm not using the word conclusion, because at the stage of investigation, you cannot conclude the liability or levy. You can merely form an observation, and basis that observation, he will link those observations to the legal provisions of the GST statute. And thereafter, he will tell the person, the noticee, what is the act of commission or omission which you have done or missed, and why this particular show cause is being issued to you. Now, this is what we call allegation. And if you ask me, this is the most sensitive part of the entire show cause. I am not saying the other parts are not important. The other parts are very important, because how the investigations have taken place. Does investigation was taken in a manner which was incorrect or incomplete? Those things are a secondary part. But what is the ultimate allegation? So if you are being raised with a demand, now demands and allegations are two different things. What is a demand? A demand can be a demand of short payment of tax or a non-payment of tax, or for that matter, wrongful availment, or for that matter, wrongful utilization of input tax credit, and thereafter any refund which you have wrongly taken. These are my demands. Why a tax of rupees 1 crore should not be recovered from you? Demand. Allegation. How the officer has observed that this particular amount or this particular recovery is to be made from the person. It is observed from your records that you are paying taxes at the rate of 5%. However, under HSN so and so, read with notification number so and so, the entry number so and so of notification provides a rate of 18% on this particular commodity. It is now hereby, you are hereby given an opportunity why this rate of 18% should not be applied and tax be so computed. Now, this is the allegation part. So, demand is not very important. What is more important is allegation. And last, once you have given an observation, you also have to link your observation to the charge, that under the legal provision, under section 9, section 11, section whatever, under what section are you creating a charge on me? Why I'm emphasizing so much? Because if this charge is not clear, the authority itself does not know under what provision has this show cause notice, the contravention has been made by the taxpayer, and therefore this show cause notice cannot be read against the taxpayer. So friends, look into the aspects, one and all, and last but not the least, please note who is the issuing officer, what is his designation, and does he what is his designation, and what is his position. All of these things are very important to be noted in any show cause notice. Now, if you summarize all of this, this has been beautifully summarized by Nasin. Nasin says, Nasin is the central body training the officers, central body. Nasin says every show cause notice must have 4 C's, capital C, C for cat. So 4 C's. What are the 4 C's? Number 1, the contravention. What has been contravened? Number 2, consequences. What are the consequences of such contravention? Number 3, the person charged person. And number 4, the charge, the allegation. So all these 4 elements are the soul of any show cause notice. If any of these 4 C's are absent, then that is not a valid show cause notice, because it will devoid you from a very fair opportunity of replying. So you have to look that these 4 C's are present in your show cause notice. Now, you have a show cause notice in hand. What is the first thing which you will see? The first thing, in my humble opinion, is you should look for the officer who has issued this show cause notice. Does that particular officer has a jurisdiction? So if you have to check the jurisdiction, the first thing which you have to check is whether this particular show cause notice has been issued by a state officer or a central officer, and what is your jurisdiction under which you have been selected. That particular question should align your selection as per the division of taxpayer of a state. That notification is very much there. You don't have to go for even that division notification. You can simply log in your GSTN portal, and you will get your jurisdictional office and the other office, meaning thereby the center or state which is not your jurisdictional will be mentioned as other office. So you log in your portal, you check for that. So number 1, whether the officer, is he the right officer in terms of center or state? Number 2, is the officer who has issued the show cause notice, does he has the jurisdiction? Now when we speak about the jurisdiction, after the preliminary jurisdiction between center and state, we divide the jurisdiction on 3 grounds. One is the territorial jurisdiction. The second is the monetary jurisdiction. One, whether that particular person has a territory available with him. Second, whether that particular person has the monetary jurisdiction, the amount till which the show cause can be issued. So suppose a superintendent issuing a 1 crore show cause notice in center is invalid, because as per the notification, as per the circular issued by the center CBIC, the monetary jurisdiction to officer is limited to 20 lakhs. So you will have to first see that these particular monetary jurisdiction are also met by the learned officer. Thereafter, the last thing which you will see in terms of jurisdiction after territorial or monetary, the notified proper officer. Why I'm emphasizing so much on notified proper officer? I'll give you a very small example. Recently, all the notices which have been issued by Delhi GST department, Delhi State GST department, the person signing the show cause notice is a VATO, value added tax officer. Now, interestingly, if you look into section 3 of Delhi GST Act, all the VAT authorities, all the VAT officers are deemed to be GST officers. So by virtue of that, their appointment is fortified, their appointment is ratified in GST also. So they become an appointed officer. However, under section 5 of the GST Act, apart from being appointed, they also need to have a notified power under the GST statute. Unfortunately, when the notification in GST was issued by Delhi GST department, uh, the functions were entrusted to authorities including an additional commissioner, uh, uh, joint commissioner, assistant commissioner, uh, GST superintendent, GST inspector, but there was no mention of the VAT authorities. So the entrustment or the notifying of the functions which can be undertaken by that particular officer who is so called an appointed officer under GST was not done under the section 5, and accordingly while he was an officer appointed, he was not an officer who has been entrusted with the power to undertake the function. So we travel back to the decision of Canon India, Honorable Supreme Court, whereby again the Honorable Court was very clear that both of these elements should be present to make a proper officer to issue a show cause notice or to undertake a particular function. And therefore, this particular officer, though he is an appointed officer, if he has issued a show cause notice, that will be a void, that will not be a valid jurisdiction which he has, and therefore this is liable to be quashed. So these particular things one must see at the inception who is the officer who has issued. Now, a proper officer has inherent jurisdiction over assessee falling within his territorial jurisdiction. But that jurisdiction has to be exercised as per the cases assigned by the designated committee. As I told you, center and state have divided, that designated committee has divided. And this particular observation, I will not say this is something which has been upheld, but this observation has been made by Honorable Allahabad High Court in the case of Ajay Verma. I request, I think some mic is open. If Naveen ji can look into it. Naveen ji?
Yes, sir.
All are muted. So.
Right, sir. Right, sir. Thank you. My apologies, but some disturbance, so I was wanting that. So sorry. मैं अपने flow में थोड़ा सा रुक गया था. I was speaking about Allahabad High Court, right? So in Honorable Allahabad High Court, in the case of Ajay Verma, very clearly observed that the jurisdiction, though it is inherent, wide the Section 3 and Section 5 read to Section 3, 4, 5 read together of the Act, the jurisdiction has to be exercised as per the case assigned by the designated committee. So this one observation should be kept in mind to look into the jurisdiction of the officer issuing the show cause notice. Jurisdiction, should it be issued at the adjudication stage only? This is also very, very important to understand. In Kedar Shashikant Deshpande, this is a Supreme Court case. The Honorable Supreme Court said that submitting to the jurisdiction of the authority is a very sensitive subject. It is well settled that if the person has submitted to the jurisdiction of the authority, he cannot challenge the proceedings on the ground of lack of jurisdiction in further appellate proceedings. So where there is a lack of jurisdiction, that is one issue, but where there is an error of jurisdiction, that is another issue. So please, whenever you are participating in any adjudicating proceedings, if you want to challenge the jurisdiction, please do it at that very level. Otherwise, the courts might call it as an error of jurisdiction if there is minor infringements in jurisdiction. Also, we have to understand that show cause notice is not the end but the beginning. बहुत सारे हमारे मित्र कहते हैं भी आज ये जो शो कॉज आया है इसके बाद तो डिमांड कंफर्म है. नहीं सर, शो कॉज आने का मतलब डिमांड कंफर्मेशन नहीं होता. शो कॉज आने का मतलब होता है कि आपको एक अपॉर्चुनिटी दी जा रही है, वो उन्होंने अपना पक्ष रखा है, वो आपसे आपका पक्ष पूछ रहे हैं और फिर उसके बाद एक निर्णय पे वो लोग पहुंचे. सर, जो ये पक्ष रखने वाली बात है, आपके पक्ष से पहले उन्होंने अपना पक्ष पूरा रख दिया. Now, what is happening is in cases of 3B2A, I'll give you a very small example. आपके पास कोई भी शो कॉज नोटिस आया, उसने सिंपली लिखा कि आपके 17-18 में 17-18 में आपके 3B के अंदर जो ITC है, that is more than the ITC which is available in GSTR 2A, and basis this we are proposing to recover this additional tax from you, is it a valid show cause notice? So before we answer this particular query, please understand some very essential elements of a show cause notice. Show cause notice is a complete document in itself. It cannot be later supplemented by anything. So अगर कोई चीज रह गई शो कॉज नोटिस में तो वो रह गई, वो डिपार्टमेंट बाद में कोई भी चीज उसके अंदर फर्दर इंक्वायरी करके ऐड नहीं कर सकता. It is the foundation for adjudication. In the very celebrated judgment, it is a 2007 judgment of Honorable Supreme Court. Brindaban Beverages, you must all be aware of it. Brindaban Beverages में Supreme Court ने बड़ा clearly कहा था, SCN is the foundation for adjudication. Any allegation, any demand which is not there in the show cause notice cannot be confirmed in adjudication. Everything what you want to propose and you want to demand should be present in the show cause notice. Now, show cause notice is also one document which can only be issued after a proper inquiry. Now, when I say this, because the very initial words of the section says where it appears. Now, where it appears is not a term based on surmises. It is not a word, it is not a phrase which says where the officer has dreamt, or for that matter, where the officer feels. No, sir. Where it appears. Where it appears means that appearance has to be a logical appearance. It is not a surmise, it is not a suspicion कि आज मैं किसी दुकान के आगे से निकला और मेरे को दिखा कि उस दुकान में बहुत भीड़ लगी हुई है, फिर मैंने ऑफिस में जाकर देखा कि भाई उसकी जो टर्नओवर आ रही है वो तो 10 लाख रुपए महीना आ रही है, और अभी अभी मैं जिस दुकान से बाहर से निकला था, मैं ऑफिसर हूँ, तो मेरे को भीड़ दिखी तो मैंने अंदाजा लगाया कि अगर 25 आदमी खड़े थे और वो 500 रुपए का भी सामान लेते हैं तो इस हिसाब से तो इसकी सेल जो है वो 20 लाख रुपए महीना होनी चाहिए. सर, इट इज नॉट अपीयरेंस, it is merely a suspicion. Appearance is a stronger word. Appearance means you are arriving at some conclusion in a logical manner, not in a suspicious manner. So that particular element should be present in the show cause notice. How it has appeared to you that this is a problem. Now, what is the problem with the 3B2A notices is, आपने 3B2A तो कंपेयर कर लिया, पर आपको ये कैसे पता जो आप अमाउंट मेरे पे एलेज कर रहे हैं रिकवरी की, वो मैंने आईटीसी अवेल किया भी है, और वो आपको कैसे पता चलेगा जब ऑफिसर ने मेरे से आईटीसी रजिस्टर मंगवाया होगा. अगर मैंने आईटीसी रजिस्टर कभी सबमिट ही नहीं किया तो 3B के अंदर तो जो आईटीसी लिया हुआ है उसकी डिटेल कभी ऑफिसर के पास गई नहीं, और अगर वो डिटेल 3B की ऑफिसर के पास गई नहीं, हाउ ही हैज मेड आउट हिज माइंड कि ये आईटीसी जो वो अलेज कर रहा है वो मैंने लिया भी. सेकंड, जो 3B2A का डिफरेंस है वो किस आइटम का डिफरेंस है, अंडर व्हाट प्रोविजन ऑफ द एक्ट is it ineligible. Those particular elements are missing in the show cause notices issued for 3B2A, and it is only an outcome because there is no proper inquiry. My dear friends, if you look into the GST statute, section 61, section 65, section 66, section 67, section 68, section 71, all these sections give special power to officer to undertake inquiry. सिंपल सेक्शन 61 ASMT 10 इशू कर दीजिए, 65 ऑडिट कर लीजिए, 66 स्पेशल ऑडिट कर लीजिए, 67 सर्च कर लीजिए, 71 आप विजिट कर लीजिए. जब आपको सारी पावर्स दी हुई है, without undertaking the inquiry, you are jumping the line straight to section 73. Is it a valid show cause notice? I think this thing need to be challenged before various courts. We are doing it. But I would request all the learned members to please look into this aspect. The show cause notice which does not have the paragraph for inquiry will always be in void. उसमें एक कमी रहेगी कि जो observation है, how is the officer has come to that observation? How has he appeared? How is it appeared to the officer that this demand is recoverable? So this is very, very serious thing, because there is a very, I will not say a thin line, it's a very clear line between a suspicion and an observation. The officer, if he wants to issue a show cause notice, he will have to fall in this zone of observation rather than a mere suspicion. Coming on to the next, sir, शो कॉज नोटिस jurisdiction हमने बात करी, हमने ये भी देखा कि इट इज द फाउंडेशन ऑफ फॉर एडजुडिकेशन. मैं यहीं पर एक चीज और आपसे डिस्कस कर लेता हूं. आपको ऑफिसर ने शो कॉज इशू किया 3B और 2A के बेसिस पे, पर जब उसने ऑर्डर इशू किया उससे पहले जब आप उसके पास हियरिंग के लिए गए तो उसने कहा कि गौरव आपने 3B 2A का तो समझा दिया कि ये लॉ में 17-18 में नहीं है, पर हमारे पास ईकॉम गिल कॉफी ट्रेडिंग कंपनी सुप्रीम कोर्ट का डिसीजन है, उसमें सुप्रीम कोर्ट ने कहा है कि भाई अगर आप कोई आईटीसी लेना चाहते हैं, दी एंटायर ओनर्स इज ऑन दी बायर. नाउ दैट इज एन इनकम टैक्स डिसीजन परचेजेस के रिस्पेक्ट में था. कॉरेस्पॉन्डिंग सेक्शन अंडर जीएसटी इज सेक्शन 155. So if you want to avail an ITC, that particular benefit you have to prove under 155. And 3B 2A का उसने मेंशन किया शो कॉज. तो अब वो आपसे हियरिंग के वक्त कहता है कि प्लीज शो मी योर रिसीट, रोड टैक्स रिसीट, और फॉर दैट मैटर धर्म काटा रिसीट, वेब्रिज स्लिप. आप मुझे प्रूफ दिखाइए हाउ दीज गुड्स आर रिसीव्ड बाय यू. नाउ माय डियर सर, दिस पर्टिकुलर मेंशन वाज नेवर देयर. दिस पर्टिकुलर थिंग वाज नेवर चैलेंज्ड इन द शो कॉज नोटिस. At the time of hearing, or for that matter in his order, he cannot write that the assessee failed to provide the proof for availment of ITC and therefore the entire ITC is disallowed. For the very simple reason, if he writes it, this particular allegation was missing in the show cause notice, and therefore this particular demand will be out of or will be traveling beyond the show cause notice. So this particular ground cannot be taken in the order. Show cause notice के अंदर जो भी होगा, it should be within the order में जो भी होगा, it should be within the allegations made in the show cause notice. So you also have to see that it is not traveling beyond the show cause notice. Next issue which you have to see is whether the service which is made for this show cause notice, is it a valid service? Now, valid service means the manner in which it is served. If it is served by speed post, is it a valid show cause notice? Sir, the scheme as provided in section 73, read with the relevant rule 142, provides that it has to be served electronically. In the case of Sham Baba edible oil, Honorable the Madhya Pradesh High Court held that the proper mechanism to serve is to upload this show cause notice on the portal. If it is not served properly, in absence of a proper service, this will not be held as a proper proceeding. So unless this particular notice is uploaded, so many a times we get a manual show cause notice. The first thing which we do is we write to the authority that this particular notice is not uploaded on the portal, and therefore it is not in compliance or it is not in consonance with section rule 142, and therefore the proceedings may not be considered as initiated. Immediately we have found that in many cases the authority immediately uploads the show cause notice on the portal, and that is the date from where the entire proceedings will start, not before that. Now please also understand, there are two columns in your portal. One is notices and orders, the other is additional notices and orders. Show cause notice should be in the notices and order tab and not additional notices and order. This was also challenged in the case of Sabari Infra Private Limited, and Honorable Madras High Court has held that SCN issued in additional notices and orders in place of notices and order in portal is not a proper place to issue the show cause notice. So kindly see, not only the mechanism, even the very place where this notice has been uploaded is very, very crucial and is being looked very sensitively by the court, because you are creating a demand against someone. How can you work in a casual manner? If you are raising a demand of 20 lakhs on a person, he will have to bear that demand from his pocket. If it is payable, he will pay. But if it is not payable, one cannot be so casual in recovering that particular amount as a right without giving the proper opportunity, and proper opportunity includes the proper service also. So again, please note Sabari Infra Private Limited. It is a Honorable Madras High Court judgment. Show cause notice should not be devoid of reason and it should not be vague. Now that is also one of the very initial pillars of show cause notice. One of the show cause notices issued to us, one of the clients came up with a show cause notice. उसमें ऑफिसर ने क्या लिखा हुआ था? It appears that the goods have not been received by the taxpayer and therefore the ITC should be disallowed. यहाँ तक ठीक था सर. Even if it is presumed, sorry, not presumed, even if it is found that the goods have been received, it is not appearing in 2A and therefore the ITC will be disallowed. Sir, you yourself are not clear whether the goods have been received or not received. Your show cause notice is vague, and on this ground alone, the show cause notice is liable to be quashed. आपको आपकी ऑब्जर्वेशन जो है बहुत क्लियरली रखनी पड़ेगी. Another show cause notice issued. It appears that the assessee has undertaken the works contract which may be taxable under HSN 9953, 9954, 9967, and so on. 3 HSNs were mentioned. Now, if the authority itself is not very clear under what HSN is the demand being raised, that demand is vague and liable to be quashed. So, when you are looking, you please look that particular show cause notice is very clear. The authority is very clear under what provision, under what notification, under what entry of that notification this particular show cause notice is issued. If it is in a vague manner or the reasons are not given, simply 3B is greater than 2A and therefore the demand is being raised. Sir, no reasons. I have no, what law I have contravened? You are not telling me. This show cause notice is liable to be quashed. So any show cause notice which is devoid of reason or on the count of vagueness can be challenged, quoting the very celebrated judgments of Allah Agarwal Dyeing and Printing Works, or for that matter, Virani Metal Industries, and for that matter, Sarvodaya Impacts. These are very recent cases of in the last 2 years of Honorable Gujarat High Court. Very beautifully authored. You can quote any of these particular decisions in these particular issues. Now, one question which Chairman CA Aishwarya ji had raised. Gaurav, what will happen if the show cause is issued without the summary or summary is issued without the show cause? Now, if you look, there is an attachment and there is a summary of that particular demand. My dear friends, जहां पे शो कॉज है और उसकी वो नहीं है, अपना समरी नहीं है, or for that matter vice versa. So where no show cause notice is issued but only summary, the same is not a proper notice, and same is the case without summary. The notice is also a invalid notice. Now this has been upheld by Jharkhand High Court in many industries. One of the very celebrated judgments is Juhi Industries. Sorry, many judgments. It has been upheld by Honorable Jharkhand High Court. So one of the judgments which I remember, which is one of the celebrated judgments, is Juhi Industries. So please look into the fact, सही ऑफिसर इसको इशू कर रहा है, उसकी जुरिस्डिक्शन में है, सही तरीके से उसने इशू करा है, सही जगह इशू करा है, प्रॉपर डॉक्यूमेंट. नाउ वन क्वेश्चन कम, समरी इज आल्सो देयर, द शो कॉज इज आल्सो देयर. शो कॉज के ऊपर DRC 01 लिखा हुआ है बट शो कॉज वर्ड नहीं लिखा हुआ. Will that invalidate? In my humble opinion, no sir. Merely a non-mention of the words show cause will not invalidate. Right, sir? Officers have also issued show cause notices which are unsigned. Now, this is very, very surprising. It came as a surprise because by putting your signature, you acknowledge two things. Number one, you understand that you are issuing the notice. Number two, you are also acknowledging that you are the author of that particular document. Tomorrow, you cannot disown that document. Any unsigned order cannot be sustained. Any unsigned notice cannot be sustained. This is again a law which has been laid down by various courts, more particularly by Delhi High Court, in the case of Railsys Engineers in the past, and many other high courts and various other decisions, including Uma Shankar Mishra by Madhya Pradesh High Court, and so on. So unsigned notice अगर है वो क्यों है? क्योंकि पोर्टल के ऊपर PDF लिया, अपलोड किया, कुछ भी साइन नहीं है, and that particular notice cannot be considered as a valid show cause notice. Approach, that is the basic question which we are again and again challenging. You are creating a demand against someone which is taking away the resources of that person. आप किसी से कुछ ले रहे हैं, मैं वर्ड बड़ा चूज करके बोल रहा हूं, आप उससे कोई चीज एक्सट्रैक्ट कर रहे हैं. So he is being divided, he is being made poorer by that particular amount. That proceedings should be respected. If someone's property is being taken away, maybe he has committed a error, he has committed a evasion, but again that is depriving him of his property. The proceedings of depriving that particular property should be taken properly, done in a proper manner. Justice should not only be served, but it should appear to have been served also. Right law. SCN जो इशू हुए हैं, आपने देखा होगा रिसेंट पास में, एक पर्टिकुलर पैटर्न पे इशू हुए और पर्टिकुलर पैटर्न पे इशू हुए हैं, तो मैकेनिकल मैनर में एक ही पैटर्न में बस सिस्टम ने जनरेट कर दिया. Now this is not a problem which is there in all states. This is a problem which is there in some states, including Telangana, including Delhi, including UP. Same pattern show cause notices the computer has generated. Officer के पास बना बनाया show cause notice आया और उसने upload कर दिया. Now these particular show cause notices are not notices which are appear to the authority. These are mechanical show cause notice without the application of mind by the authority. The pattern and the mechanism of these particular notices can be shown to the court, and this is very, very important, because if the officer has not issued a show cause notice, he never understands what is the allegation. आपने अगर कोई चीज बनाई नहीं, आपने कोई डॉक्यूमेंट बनाया ही नहीं है, आपको पता ही नहीं है कि क्या कॉन्ट्रावेंशन है, क्योंकि ये बल्क में इशू हुआ है. एक व्यक्ति को इशू नहीं हुआ कि आपके पास बहुत टाइम है. कम से कम हर ऑफिसर के पास 500, 600, 2000 नोटिसेस है. अब क्या उसके पास इतना टाइम है कि उसको पता नहीं है कि ये 2000 नोटिसेस इशू कैसे हुए हैं? वो एक एक नोटिस को जस्टिफाइड टाइम दे पाएगा? Now this was also a case which happened in case of orders, where the system passed the orders in a mechanical manner, and those particular notices, orders were uploaded in the system. This happened in the case of Delhi, I think under Delhi VAT. And in the case of Bhumika Enterprises, all these system generated orders were quashed because they were held to have been issued in a mechanical manner without specifying relevant particulars, and were held to be invalid orders. So please understand, same fate will be, will happen to show cause notices also. Friends, शो कॉज नोटिस ना एक टाइम बाउंड एक्सरसाइज है. ऐश्वर्या जी का एक क्वेश्चन ये भी था, हमें कितने टाइम के अंदर इसको एड्रेस करना चाहिए. मैं आप सबसे एक ही चीज कहूंगा, आपको इसको एक रीजनेबल टाइम में एड्रेस करना चाहिए. क्यों? उसके दो कारण हैं. सबसे पहला कारण, सबसे पहले विद इन 5 days of receiving the show cause notice, you should make up your mind. Are you wanting to contest this particular notice? Now, when I'm saying you should make up your mind, it means in discussion with your client. योर क्लाइंट शुड अंडरस्टैंड कि क्या वो इस नोटिस को फाइट करना चाहता है। वो मैं क्यों कह रहा हूं, क्योंकि 73 में भी और 74 में भी जो 30 दिन का टाइम है फ्रॉम द डेट ऑफ इशू, देयर इज अ स्पेशल रिडक्शन ऑफ पेनल्टी विच इज प्रोवाइडेड कि अगर आपने 73 का 30 दिन के अंदर टैक्स और इंटरेस्ट पे कर दिया, पेनल्टी वेव। 74 का कर दिया ऐश्वर्या जी, आई थिंक 15% पेनल्टी, which increases to 25% and then to 50% and then to 100%. So पहले 30 दिन का महत्व बहुत बड़ा होता है। इस फेज में सबसे कम पेनल्टी लगती है। अगर आपने 2 महीने बाद ही डिसाइड करा, आपकी टेबल पे पड़ा, आपके पास टाइम नहीं है, फिर आपने अपने क्लाइंट को समझाया, अरे यार इसमें तो लड़ने का कोई ग्राउंड ही नहीं है, तो गलती है। अरे बॉस, तो गलती पहले 5 दिन में डिसाइड कर लीजिए। आपको लीगल बैटल लेने में टाइम लग सकता है, पर यह फैसला करने में थोड़ी टाइम लग सकता है कि ये गलती है कि नहीं है। तो पहले 30 दिन के अंदर, मैं कह रहा हूं पहले 5 दिन के अंदर आते ही सबसे पहला फैसला, क्या हमें इसको फाइट करना है। अगर करना है तो पे करिए, खत्म करिए। डोंट क्रिएट लिटिगेशन इन दी कंट्री। लिटिगेशन शुड ओनली बी फॉर द राइट, नॉट फॉर द सेक ऑफ कि इसको इस टेक्निकल मैटर पे ले जाएंगे, उस पे ले जाएंगे। सर, डोंट क्रिएट लिटिगेशन। एम्पल लिटिगेशंस आर देयर इन दी कंट्री। जिसकी जो डिमांड बनती है, और अगर उसका शो कॉज बन गया है, मे बी आई एम वन पर्सन हु इज वेरी क्लियर, अगर वो डिमांड बनती है और सामने डीआर अगर खड़ा होकर कल को इस्टेब्लिश कर देता है, तो कोर्ट्स, इवन दो देर आर प्रोसीजरल इन्फ्रैक्शंस, बट देर इज नो मीट इन दी मेरिट, I don't think courts will take the recuse to the person who is admitting the liability, but mere procedural infractions. Any person who has a genuine reason, courts will always come to protect every single innocent man. But if someone is guilty, that particular proposition, if he knows he is guilty and he don't want to contest, mere on procedural infractions, don't create a litigation. That's my humble request to all my learned friends. शो कॉज नोटिस हमने देखा, उसके कंटेंट्स हमने देखे। एक क्वेश्चन और उठता है, क्या फ्रेश शो कॉज नोटिस इशू हो सकता है सेम पीरियड का? सर, बिल्कुल हो सकता है। पर क्या सेम इशू के ऊपर हो सकता है? सर, बिल्कुल नहीं इशू हो सकता। सेम पीरियड, same issue, 2 show cause notices cannot happen. It has to be one single show cause notice for one issue, one year. Now this is held to be devoid of jurisdiction in the case of Union of India versus Vico Laboratory. It is a Supreme Court decision. Fresh show cause notice for same cause of action for same period against which the order has been passed cannot be issued. In the case of Vico Laboratory, it was held that reopening concluded assessment amounts to abuse of process of law. And same will be the fate with show cause notices. It will help you in case you are undergoing multiple investigations and show cause notices are issued at different point of time by the authorities. For the same period, 2 assessments are not permissible. That is very much held by Honorable Supreme, but that is more in the context of income tax. The context of income tax and GST are a bit different. But to fit an income tax decision in your context, the context should align. So if there is an inquiry, if it is an audit covering all aspects, then there cannot be a ASMT 10 which can be issued. It will be a reassessment of the assessed. Then Duncan Industries will come to your rescue, Honorable Supreme. Otherwise not. Amount of demand should be determined in SCM. Now, ये एक एस्पेक्ट था जो हमने देखा यूपी के अंदर। कुछ शो कॉज नोटिस में ये लिखा आया, ये हिमाचल के में था, सॉरी। You are hereby requested to provide the figures for April 17 till September 19 so that the amount can be computed. सर, आपने शो कॉज नोटिस इशू कर दिया है। शो कॉज नोटिस विदाउट अमाउंट इज a void show cause notice. The demand amount, penalty amount, interest amount should be very clearly put in there. Interest के ऊपर थोड़ा सा open issue है. It is yet to be tested because interest amount up to the date of issue of show cause should be put in the show cause notice. Thereafter, it will be recomputed. The assessor will still need to pay. But up to the date of show cause notice, interest amount should be specified. What we have seen is, in many cases, tax is there, penalty is there, but interest amount is missing. So, interest can itself be challenged that if the summary says 0, but the grounds in the show cause says it will be computed later. In my humble opinion, it is a contestable thing that officer never demanded the interest in the summary. I will only take a decision based on the summary of my demands which has been issued under section 73. Again, if the tax is not decided, then it has already been held by Madras High Court in the case of Hudson Agro that this particular show cause notice will be void. Now, another very important thing is whenever a show cause notice is issued to you, very recently, स्टेट के जो शो कॉज नोटिसेस है वो इतने कॉम्प्लिकेटेड नहीं होते, बट सेंटर के जब होते हैं, जब इन्वेस्टिगेशंस वगैरह होती हैं, दे कोट वेरियस डॉक्यूमेंट्स. हमने ये स्टेटमेंट ली, उसमें सामने वाले ने ये एडमिट किया, हमने ये छापा मारा या सर्च करी, वहां पर हमारे को ये मिला, तो वहां का पंचनामा. There are many relied upon documents in that particular show cause notice which are being spoken or relied upon. Has the show cause provided the copy of all relied upon documents? If it is not given, then it is again devoiding the SSC of a valid or a proper opportunity of being heard. It has again been upheld in many cases, including Kanwar Natraj Singh versus Directorate of Enforcement, Supreme Court. So, आपको अगर अपना पक्ष रखना है तो आपके अगेंस्ट जो भी सामने वाले ने एविडेंस इकट्ठे करे हैं वो आपके पास उसको कॉपी देनी पड़ेगी. Then only you can fight those particular cases, otherwise not. Summary in electronic form is required to be furnished along with SCN. I have already spoken on that. Sorry. Show cause notice अगर कोई एलिमेंट इन टर्म्स ऑफ कॉन्ट्रावेंशन नहीं बताता है तो वो भी एक चीज है जो शो कॉज नोटिस को अधूरा बनाती है, which again goes to the spirit of a proper and fair hearing. Now, my dear friends, many of us will say section 169 keeps very much many option to serve. But my dear friends, when rule 142 chooses out of those particular provisions a very specific provision, which is electronically, the choice with the officer to issue SCM in other modes is ruled out. So मैंने already ये वाला भी part आपके साथ discuss किया है. I am just reiterating this particular part because service की जो महत्व है वो adjudication stage पर ही उठाई जा सकती है. Once you have participated in the proceedings, thereafter the relevance subdues. But if you challenge and then you participate, then thereafter the challenge, if it is not addressed, that will go in your favor. एक क्वेश्चन और आया था सर, DRC 01A क्या मैंडेटरी है इशू करना? Now up to 15th of October 2020, the language of the rule 142(1)A. I am just reading out that provision for you. Rule 142(1)A कहता था, sorry, just one more second. The proper officer shall serve before service of notice to the person chargeable with tax, interest or penalty under subsection 1 of section 73 or 74, as the case may be, communicate the detail of any tax, interest or penalty in DRC 01A. Now, this was using the word shall up to 15th of October 2020. So, it was mandatory for any officer who wants to issue a show cause up to 15th of October 2020 to issue a DRC 01A to the taxpayer. Now, question was, when we say up to 15th October 2020, does it mean the period up to 15th October or the show cause notice which were issued up to 15th October? This question came up before Andhra Pradesh High Court in the very recent judgment in the case of New Morning Star Travels. The Honorable High Court has held that DRC 01A is mandatory for demands up to period from 1st of July 17 till 14th of October 2020. So even though SCNs are issued after 15th October, but for the period up to 14th October, it has to be read that they need to issue DRC 01A. Now comes the second question, sir. मेरा शो कॉज नोटिस इशू हुआ है 15 अक्टूबर के बाद फॉर द पीरियड आफ्टर 15th अक्टूबर. न्यू मॉर्निंग स्टार का हम पीरियड एक बार एक्सक्लूड कर देते हैं. सो अगर कोई 19-20 के मार्च 20 की कोई लायबिलिटी है, या सॉरी फॉर दैट मैटर मार्च 21 की कोई लायबिलिटी है, क्या ऑफिसर के लिए DRC 01A इशू करना मैंडेटरी है? वहां पे वर्ड है मे. सर ये तो चॉइस होगी ऑफिसर के पास. He may issue, he may not issue. Shall was mandatory, may is not mandatory. That's a trite law. But will it mean that may will only be read as may, and the choice is very, very subjective to the surmise or to the option of the officer? No, sir. Ordinarily, the word may is directory. इसकी प्लेसमेंट itself इसकी रेलिवेंस को जताती है. अगर गवर्नमेंट को ऑफिसर को इसको इशू करने की चॉइस देनी थी और ऑफिसर्स को कहना था क्या जरूरत है जब चॉइस ही है, तो फिर इस प्रावधान को यहां रखने का कोई महत्व नहीं रह जाता. इफ देयर इज अ प्रोविजन इन द लॉ, then that has to be read and respected in that manner. The expression may confers discretion, and discretion has to be addressed in a very judicious manner. That prima facie presumption about a provision being imperative may be rebutted by the other considerations such as scope and consequences following from such construction. ये word may की जो deciphering है, ये ऑनरेबल सुप्रीम कोर्ट ने एक्सिस बैंक लिमिटेड with the Vidarbha Power versus Axis Bank, it is a very recent judgment of 2022 उसमें करी. So may has to be seen in the context where it is placed and what are the consequences arising out of it. If I have to put it in context of GST, DRC 01A may will be read as you have to intimate the demand before issuing show cause. Now suppose there is an audit which has happened, किसी का audit हुआ, ऑफिसर ने उसको audit memo दे दिया, सारी demands लिख कर दे दी, तो सामने एसएससी को पता है कि what are my demands which are going to be raised. In this particular case, sir, DRC 01A is not mandatory. May will go to the favor of the officer. He has already communicated the demands. But any show cause notice which has come out of blue, where there is no single event where demand was communicated to the taxpayer, then this may will become shall for the officer that you need to issue DRC 01A because you never communicated the demand before issuing the show cause, giving him an opportunity to conclude the proceeding. So please read this particular word in a sensible context. Show cause notice and natural justice are intertwined. Any proceeding in show cause notice will have to justify all the principles of natural justice. It is the essence of fair adjudication, and to reach a judgment, it is imperative to follow all the principles of natural justice. Now coming on to the question, is hearing a must? Section 75 subsection 4 of the GST statute requires the officer to provide an opportunity of being heard mandatorily in case of an adverse order to the taxpayer. And this is also deep-rooted in the principles of natural justice that no one should be condemned unheard. You can refer to n number of judgments in these particular cases that hearing is must as per law. Party time hospitality versus State of UP, Allahabad High Court, Bharat Mint judgment of Honorable Allahabad High Court, for that matter, Madras High Court or Supreme Court, Yunus Khan. All these judgments go to state that no one can be, the matter cannot be decided without hearing the part who is under the allegation or who is to be the matter against whom has to be decided. So
Sir,
please,
Gauravji, sorry to interrupt, but we have 10 minutes more. Then we need to take questions also.
Aishwarya ji, take my words. Another 5 minutes I'll close.
Okay, thank you so
मेरी
much.
घड़ी मेरे सामने है और मैं बिल्कुल देख रहा हूँ 5:25 हो गए हैं. So without taking, so 5:30 we'll close. We'll take up questions.
होना तो चाहिए.
So sorry. अच्छा, आपकी जब हियरिंग की बात आती है तो ये चीज का ध्यान रखिएगा कि प्रॉपर नोटिस which contains the time, authority, place, nature of hearing is given in that particular notice. Suppose the person says before deputy commissioner, but he does not provide कहाँ पर आना है, कौन से ऑफिस में बैठा है. It is not a proper notice of hearing. टाइम नहीं बताया कितने बजे आना है, सुबह 10 बजे से 5 बजे तक कौन सी टाइम है हियरिंग की. It is not a proper notice for hearing. डेट्स जो है वो इनऑल्टरनेट दे दी है. आप एक काम करिए, 22 से 25 के बीच में कभी भी आ जाइए. Incorrect notice of hearing. These all notices have to be very precise. What is the authority? What is the place? What is the time? It has to be given in a very clear manner. Otherwise, this will vitiate the entire hearing proceedings. It will take away the very right from that person.
थारो ही होना चाहिए.
Some mic
Naveen
is
ji,
on.
Naveen ji, the some mic is on. Very quickly, last part of my deliberation, I can speak on other aspects also, but looking into the paucity of time, I'll very quickly come to the reply part. I'm posing some questions before you. If you are able to answer those questions, your reply, in my humble opinion, would be adequate and suffice. Whether SCN is issued within time. Whenever you say yes, you don't have to take that as a ground. Whenever you say no, take that as a ground. Whether SCN is issued by the proper officer, does he have the jurisdiction? Whether SCN has been served in the proper mode, whether SCN contains proper legal provision, whether SCN has the proper contravention, whether SCN is duly signed by the officer, whether SCN is also accompanied by the summary of SCN, summary of demand, whether SCN contains all the relied upon documents, whether SCN has provided the specific instance or the contravention to you. Now coming, so these are the elements of SCN. Coming on to the second part, after you have seen that it is served properly, so it is uploaded on your portal, is it also having an adequate notice of hearing, which is very clear in terms of date, time, and location? Does the SCN, the hearing extension, if you are saying, does it, the option of extension is given to you? Whenever you are choosing the extension, please also note that there will be a limitation for passing the order. Don't stretch it too long for the officer, otherwise the decision, even if it is passed in an ex parte manner, will go in the favor of the officer, because it is you who is taking undue adjournments. When you are replying to the SCN, considering these particular things, do you need a cross-examination of any of the persons whose statement has been relied? So there is a third party whose statement has been relied. There is a third party whose documents have been relied. Every right of cross-examination is there with you. Do take cross-examination. Right, sir? Please mention number one. Don't replicate the show cause notice. Many of my friends are, I have seen, they replicate the entire facts, everything. Kindly please take the relevant facts. Relevant facts, when you say, you don't miss out on anything. There will be something which will be adverse for you. please do not also miss those particular parts. Be fair. If you really want to win your case, be fair and then take out the legal aspects, how that particular position can be challenged. If there are unchallenged position in your reply, meaning thereby you try to run away from a situation, that particular demand confirmation will always go against you. So address the adverse parts or agree to them, whatever the case may be. Next, एक बहुत अहम बात लोग भूल जाते हैं. सपोज देर इज अ टैक्स डिमांड. मैंने एक सबसे पहला एग्जांपल लिया था 5% और 18%. आपकी डिमांड आपने 5% पे पे कर रखी है, कलेक्ट भी आपने 5% पे करा है, पर ऑफिसर आज 18% मांगे. Now you cannot go to your buyers and tell them ki please pay me extra 13%. Now this 13% will not be levied absolute on you. It will be computed in a cum tax manner. Take that ground. So earlier you collected 105 rupees, 100 plus 5. 18 rupees you cannot pay on 100. You will be computing the demand 105. So this is as per section 15 read with the roots. 105 divided by 118 into 80, not 100 into 80. So this will, in many cases, when the demands are of good magnitude, we have seen that this particular cum tax itself saves some lakhs or crores for the taxpayer. I think I have covered everything. It's already 5:30. There are certain things which still can be taken up, like writ jurisdiction or things like that. But I think I'll like to conclude my deliberation here. And I would like my chairman to decide if anything is left, we can take that up.
Thank you so much, Gauravji. Actually, you have covered various topics in a very clear manner, and I'm sure these all things have been clarified to the participants. But a very common question which is coming up here is like you have mentioned about various lapses, which we must check whether it is in our show cause notice, like whether the summary is enclosed or not, whether it is uploaded in time, or various other things, whether they have properly mentioned the contraventions and all. But it is, as you mentioned, that there are various show cause notice which are being issued in template form. The officers are getting templates. They are just copying, they're doing copy paste and issuing to the various taxpayers. So how to challenge the show cause notice means on the basis of the lapses, because whether these things to be challenged before the High Court only, or it can be challenged before the officer who has issued, or we have to address this in the time of when we are fighting it at the time of appeal or anything.
See, Aishwarya, this one question whether the show cause notice can be challenged in writ jurisdiction ordinarily. And I can tell you, Calcutta High Court is the High Court which has laid down the law, very clear law. It's a beautifully worded judgment, authored judgment. In the case of Indian cardboard industries, where the context when it can be challenged in writ, a show cause notice. Usually, the law is courts will not interfere at the time of show cause notice. They will not evoke their extraordinary jurisdiction under Article 226 at show cause notice. But if show cause notice, if the noticee can, the petitioner can demonstrate that show cause notices expressi is illegal, or for that matter, it is based on admitted facts which does not disclose the offense. Number two, when show cause notice is issued without jurisdiction, officer never had the jurisdiction, he issued. For that matter, show cause notice suffers from an incurable infirmity. It does not has the demand amount. It is an incurable infirmity. When show cause notice is contrary to the precedents already decided by the jurisdictional High Court or for that matter Supreme Court, in these cases, writ jurisdiction can be taken up. And the decision whether to take it in writ jurisdiction or not is also very, very important, because अगर वो demand confirm होती है, at the appellate stage, you have to deposit 10%. So in many cases, we have seen clients assesses cribbing that, sir, मेरा इतना टैक्स बनता नहीं है, आपको क्लियरली दिख रहा है, इसमें 2 करोड़ का डिमांड है, 20 लाख रुपए में कहां से जमा करूं? सो ये जो एक अहम क्वेश्चन है, बहुत सारे सर्कमस्टांसेस को देखते हुए आपको डिसाइड करना. यू विल नॉट गो फॉर अ रिट इन द केस ऑफ 5 लाख रुपीस ऑफ डिमांड.
Exactly, means the
And
amount of the
when
demand accordingly decide
हाँ,
करना.
so आपको ये देखना है आपको खांसी जुकाम है या आपको वाकई ऑपरेशन की जरूरत. रिट इज अ सर्जरी, इट्स एन ऑपरेशन. So
Right.
go for RIT when it is actually needed. Otherwise, follow the normal route. It's a cheaper, easier, and permanent. Maybe the show cause notice is quashed. Department again issues you another show cause notice. So what benefit have you got? But if that show cause notice, which is weekly worded today, you went into a RIT. Uh, Department got to understand their problem. They now issues you a show cause notice with all the infirmities taken out. So
Right.
what good have you made to the taxpayer? You have created a damage. So
Right.
only in case of extreme cases prefer a writ. Otherwise, choose the normal route.
Another issue which was raised is कि जैसा आपने कहा कि service of show cause notice should be done online only in DRC 01 through the GST portal. But there is section 169 which says there are various other modes for serving a document like any notice, letters, or any order. So how do we address that? We see that officers say हमारे पास दूसरे options भी हैं as per section 169.
ऐश्वर्या जी, मैंने पहले कहा था, सबसे पहले मैंने यही मेंशन किया था, 169 जो है वो एक सेक्शन है पूरे एक्ट के लिए, वो सिर्फ शो कॉज के लिए. हाउ नोटिसेस एंड ऑर्डर्स विल बी सर्व्ड. नाउ देयर आर मल्टीपल नोटिसेस एंड ऑर्डर्स, but for a show cause notice under section 73, when the rule 142 is very specific,
Right.
the officer is left with no choice but to follow the rule. If the rule was lenient, why this rule kept it electronic? Because the department or the legislature, the lawmakers wanted this entire demand structure to be electronically what do you call that, electronically maintained. उसका एक बहुत बड़ा मैं आपको रीजन और बताता हूँ. बहुत सारे नोटिसेस आप अगर देखेंगे एक्साइज और सर्विस टैक्स में जो डिमांड्स है वो सारी एक्सेल बेस्ड है. डिपार्टमेंट अपनी पूरी रिपोर्टिंग एक्सेल पे कर, या उनका जो सॉफ्टवेयर है विच इज नॉट लिंक टू दी show cause notice which are manually issued. So there is no tracking of those particular things. When everything will be electronic, it will be clearly visible to the department as well as to the taxpayer कि ये एक्शन हो गया है. और यहाँ पर एक और छोटा सा क्वेश्चन में डालना चाहूंगा. बहुत सारे मेंबर्स अपने टैक्सपेयर्स में अपना फोन नंबर और अपना मोबाइल आईडी दे देते. माय डियर सर, प्लीज डोंट डू दैट फॉर द वेरी सिंपल रीजन, कोई शो कॉज आ गया, उसका जो इंटीमेशन है वो आपके पास आएगा, और अगर आपने मिस कर दिया, एक्स पार्टी ऑर्डर विल मे नॉट बी decided in favor of the taxpayer by the court, because it is the fault on the part of the taxpayer or the chartered accountant. एंड मोर इम्पोर्टेंटली, अगर अपील का केस बनता है, ऑर्डर पास हो गया, फिर भी आपने ध्यान नहीं दिया, सिंह ब्रदर्स सुप्रीम कोर्ट विल कम इन अगेंस्ट यू. वो ये कहता है कॉन्डोनेशन का पीरियड 3 महीने प्लस 1 महीना, 1 महीने का कॉन्डोनेशन है. आप 5 महीने बाद जागे तो सर आपके पास तो कॉन्डोनेशन के लिए भी एप्लीकेशन लगाने का टाइम नहीं है. सो दिस इज वेरी इंपॉर्टेंट टू अंडरस्टैंड. If you are wanting to enjoy all these benefits, you have to be agile. A person who is not agile, the law will not come to support that particular person. Aishwarya.
Yes, sir. So जैसा आपने कहा कि section 169 is general in nature and the rule to section 73 specifically says कि show cause notice DRC 01 is to serve online. अब इसमें सर एक इशू आता है कि जैसे 17-18 के शो कॉज नोटिस अंडर सेक्शन 73 करने के लिए लास्ट डेट था से 30th सितंबर 2023. अब इसमें कई इंस्टेंसेस ऐसे हैं जैसे सेंट्रल फॉलोज अ मैकेनिज्म ऑफ सर्विंग द शो कॉज नोटिस थ्रू पोस्ट. तो किसी का अगर स्पीड पोस्ट या रजिस्टर्ड पोस्ट के थ्रू उनको 30 सितंबर के पहले शो कॉज नोटिस सर्व हो गया है एट द लास्ट एज ओनली 22nd और 25th सितंबर, बट उन्होंने ऑनलाइन उसको अपलोड किया इन अक्टूबर 4th या 5th अक्टूबर 2023 को ऑनलाइन उन्होंने जीएसटी पोर्टल में अपलोड किया. क्या अब उसको चैलेंज किया जा सकता है ये बोल के ये टाइम बार?
I would love to challenge it as a time part because again it is not a convenience for them.
Right.
अगर वो अपनी किसी भी लिमिटेशन के बियॉन्ड चीज को कर सकते हैं, which is only a one-sided act.
Right.
Same benefit should be given to the taxpayer. Which is not the case.
Absolutely. Thank you. Next issue is for personal hearing. पर्सनल हियरिंग लाइक कितने बार होता है कि शो कॉज नोटिस को एडजुडिकेट कर दिया जा रहा है। जैसे आपने कहा कि एडवर्स डिसीजन है, तो एडवर्स डिसीजन में इट इज़ मैंडेटरी टू गिव शो कॉज नोटिस। बट क्या हो रहा है कि ऑनलाइन जीएसटीएन पोर्टल में जब हम DRC-01 का रिप्लाई फाइल करते हैं, तो वहाँ पे ग्लिच है, जिसके कारण में जब आप फाइल कर देते हो उसके बाद वहाँ पे दिखता है ऑप्शन फॉर पर्सनल हियरिंग नो। तो वो टैक्स ऑफिसर को ये कन्वे हो रहा है कि ही ऑप्ट फॉर डज नॉट ऑप्ट फॉर पर्सनल हियरिंग। एंड इन दैट केस अगर वो उसके अगेंस्ट में अगर वो डिसाइड कर रहे हैं शो कॉज नोटिस को, तो स्टिल इज इट मैंडेटरी टू गिव पर्सनल हियरिंग एज पर सेक्शन 75?
Yes, sir. It has to. There is no choice with anyone when the statute provides it very clear. आप even if you waive and he is wanting to pass an adverse order, मैं तो बहुत extreme बोल रहा हूँ, then also one personal hearing will be required to be given.
देन एक क्वेश्चन था सर, जुरिडिक्शन रिलेटेड है कि अगर कोई स्टेट जुरिडिक्शन का एसएससी है बट उसका सेंट्रल जुरिडिक्शन से शो कॉज नोटिस इशू हो रहा है या वाइसे वर्सा, तो इज इट अ वैलिड शो कॉज नोटिस?
Sir, I am again telling you the jurisdiction can be challenged. एक बहुत अहम क्वेश्चन आता है कि इन्वेस्टिगेशन की पावर्स जो है वो जीएसटी काउंसिल ने डिसाइड किया था सेंटर और स्टेट दोनों के पास रहेंगी। फिर उसके बाद सीबीआईसी ने एक सर्कुलर इशू किया कि whosoever initiates the proceeding will take it to its logical conclusion. Right, sir? In my humble opinion, there is still a lot of questions which need to be answered before which need to be raised before the honorable high courts. कि investigation की power open है, but उसका जो show cause notice है that can only be issued by the proper officer in whose jurisdiction and under the designated authority in whose division the assessee falls. So my humble opinion, it has to be in the correct jurisdiction and in the correct division as per the designated committee.
Okay. Next question is कि whether SCN for 17-18 can be issued now as time for order of 3 months is not available now.
देखिए
I think वो शायद 74 के होंगे।
73 का इशू नहीं हो सकता, 74 का अभी भी फरवरी 25 तक इशू हो सकता है। सो थोड़ा सा सतर्क रहिए, अभी सारी डेडलाइंस नहीं निकली है, सो स्पीड मत बढ़ा दीजिएगा कि किसी भी टैक्स पेयर को आपने कह दिया कि अब तो तुम बरी हो गए हो, सारे शो कॉज खत्म हो गए। नहीं साहब, इवेजन के केसेस में अभी भी शो कॉज नोटिस की ऑप्शन गवर्नमेंट के पास ओपन। गो स्लो, लुक एट द केस, अब जो भी शो कॉज होंगे वो 74 में।
देन एक क्वेश्चन था कि या एक इशू था कि देयर इज अ लाइन इन द शो कॉज नोटिस कि सप्लीमेंट्री डिमांड कैन बी इशूड विथ न्यू एविडेंस। इस शो कॉज नोटिस में ये लिखा हुआ आ रहा है कि हम अभी भी आपको कोई सप्लीमेंट्री डिमांड इशू कर सकते हैं विथ न्यू एविडेंस ऑल्सो, तो क्या ये सही है?
वो हो सकता है शो कॉज में ये भी लिखा हो कि वी कैन ऑल्सो मेक अ न्यू लॉ टू penalize you. That is not possible. That is not possible. They are creating the law. Administrative officer cannot create the law. The law mandates a issuance within a time frame limitation. He is bound by that. He cannot extend that time by just writing a line. I am keeping my option open. No, sir. तो पहले ही रिफंड क्लेम में एसएससी को लिख देना चाहिए, I will also file many other refund claims in future. फिर उसको भी अपनी लिमिटेशन ओपन मिल जाएगी? नहीं मिलेगी सर। प्लीज।
ये तो है? तुम 1 घंटा से बाथरूम से निकला है? हाँ? अरे तो 1 घंटा तक कर रहा था क्या तुम कोई?
नवीन जी, ये लड़ाई हम यहाँ पर रोक सकते हैं सर।
डन सर।
प्लीज चलिए ऐश्वर्या जी, नेक्स्ट क्वेश्चन।
अगेन एक है कि ट्रान 1 रिलेटेड इश्यूज का भी अभी शो कॉज नोटिस इशू किया जा रहा है आफ्टर 30th of September। मतलब ट्रान 1 which was claimed in 17-18।
Tran 1, if you look, Tran 1 is a issue which is very very litigative because Tran 1 का जो demand है ना, that is in relation not to input tax credit, that is an availment of the erstwhile taxes, and the demand of those particular thing can only be raised under the erstwhile taxes. अंडर द जीएसटी regime unfortunately 73 or 74 के अंदर ITC की बात करी है, and claim of erstwhile taxes does not fall within the definition of input tax credit as defined under section 2 of the CGST Act. So look into this particular aspect.
Then ये गौरव अग्रवाल जी का क्वेश्चन it doesn't appear clear. इसमें लिखा है suppose in DRC 01 demand is levied for 1 crore but in annexure it is only rupees 10 lakhs. So ultimately demand will be considered for 10 lakhs. Do we need to contest before the officer only against ground of 10 lakhs?
See, any demand which is devoid, which is without any basis, any allegations, is a baseless demand. So for balance 90 lakhs, kindly please do mention in your reply that these 90 lakh rupees are devoid of any allegations and therefore they are liable to be quashed. Don't keep that open.
शायद उनका ये बोलना है कि DRC 01 फॉर्म में जो 01 है उसमें ऊपर में कंप्यूटराइज फॉर्म में 1 करोड़ वो जो समरी है या एनेक्शर टू दैट शो कॉज नोटिस में शायद वो 10 lakhs का
I think I've got the question right, Aishwarya ji. चलिए, next one.
श्योर इसमें शो कॉज नोटिस रिलेटेड तो और ऐसा क्वेरीज नहीं है.
चलिए, so I think I must thank, before I must thank Views Exchange. I must thank Nitesh Moreji to again remember me and make me a part of his wonderful initiatives which we always take in Kolkata. I must thank my session chairman Aishwarya Agarwal ji, who has been kind to give me ample space and time to present my deliberation, and to my wonderful listeners who has been there with for the last almost 1 hour 45 minutes with us on such 6 साल बीत गए हैं, जीएसटी को लेके सब बोर हो गए हैं, still my very learned friends are still they are keen learners, they are keen sharers. उनकी हर डिस्कशन से एक स्पीकर भी कई बार नए पॉइंट्स लेकर जाता है, और एज ऑलवेज कोलकाता ने कभी मेरे को खाली हाथ नहीं भेजा है. सो कुछ नई चीजें सीखकर मैं हमेशा ही जाता हूँ. आई थैंक ईच एंड एवरी वन ऑफ यू टू गिव मी सच अ वंडरफुल अपॉर्चुनिटी. Aishwarya ji, over to you, sir.
Thank you so much, sir, for giving your wonderful deliberations, and you have covered all the topics and all the queries very nicely and very detailed manner. I don't think any other issues are left for the participants. So that's all, and over to Manu Rishi ji.
Thank you, sir. Now I hand over to CA Suman ji for the vote of thanks.
Yeah, thank you, Mani Rishi ji. Thanks to our learned speaker Gaurav ji. He has given his ample time and explained in elaborate way how the things can be handled after the GST. It seems that it is very easy to handle, but as those days are going on, people are thinking that whether it is the easiest tax or the toughest tax. So speakers like you highlighted the points where the practitioners like us goes into any problems or having any hitches of the understanding the law. So, sir, you are the first one to learn the law and make us learn the law. So, as a key referencer, you are always there with all the professionals. I also thank all the participants, without which any of the seminars is not successful. But heartiest thanks to our learned speaker Gaurav Gupta ji and the chairman of the session, Aishwarya Agarwal, who seems to be in the same batch of the GST training program. We are in the same batch. So, after seeing Aishwarya after so many long days, it's very good too. And also thanks to the convener of the study circle, Nitesh Morji, Mani Rishi ji, with the heartiest thanks from Views Exchange. Sir, you are always there for us, and we'll also always be see you in any of the platform. Thank you, sir. Thank you very much. Good night.
लेकिन गौरव जी ने वोट ऑफ थैंक्स भी दे दिया. आपने वोट ऑफ थैंक्स भी दे दिया हम लोगों को. माने आपने
नितेश जी, ये आप सबका प्यार है और मुझे बहुत अच्छा लगता है जब आप याद करते हैं कभी मेरे को अपने किसी भी आप अपने जो प्रोग्राम्स हैं उनका पार्ट बनाते हैं. इट इज ऑलवेज माय प्लेजर
ऑल्सो my pleasure also, and delegates, all the participants, our members loves you so much.
Yes.
Thank you, sir. Thank you.
Thank you, sir. Thank you.
And you are our professional colleague also. You are chartered accountant also. So that is
Yes.
our honor that you are there.
My pleasure always, sir.
Thank you. Thank you. Manu, you can stop the
Yeah.
Good.
So participants, tomorrow again we have a third session on this GST program. We will start sharp 4 p.m. with another learned speaker. So tomorrow we will waiting again for you. Thank you, everyone.
Nitesh ji, I would need the copy of all the questions which were raised today. Chat में जो है तो उसकी copy दिलवानी.
मनु ऋषि जी थोड़ा सा हमको सर को भेज दीजिए ना.
हाँ,
चैट से कॉपी
ठीक है.
कर लीजिए.
ऐश्वर्या जी, आपके पास नोटेड है क्या, या आपने चैट
मेरे
बॉक्स से
पास
लिया?
नोटेड है, मैं समराइज करके भेज देता हूँ.
हाँ, आप मेरे को
Done.
व्हाट्सएप कर देंगे तो
Best
मैं
है.
फॉरवर्ड कर दूंगा. ओके,
Sir.
थैंक यू.
Hello,
Thank you.
sir.
थैंक यू एवरीवन.
थैंक यू सर.
कोई कुछ पूछ रहा है क्या? Yeah.
So, will the
Tell me.
recording be provided for the classes?
Yeah, you can. All the
ये-
recordings are there at our YouTube channel. The
Correct.
YouTube channel name is Views Exchange. So just
Sorry?
go to the YouTube Views Exchange. VIEWS Views EXCHANG. Views
Okay.
Exchange.
Okay.
This is the name of our YouTube channel. You go there, you will find the recordings for this program and other programs also. That is there.
Okay. Okay. Thank you so much, sir.
Thank you so much. Thank you Manu Rishi. Thank you गौरव जी.
Yeah.
अच्छा लगा. बढ़िया हो गया.
Thank you, sir. Thank you.
Thank you. So leaving for today.